Thank you. Please be seated. Elizabeth, do you have the sign-in sheet? Good morning. We're here for oral argument in case number CV19-0173, Helen Hauser et al. Versus City of Phoenix et al. Council will remind you of just a couple of things. So each of you will have 20 minutes to present your arguments. Counsel for appellant, if you watch the clock, and reserve as much time as you'd like for rebuttal. Also, please keep in mind we read the briefs and we have discussed the case and are familiar with the basic facts of the case. With that, counsel for appellant, you may proceed.
Thank you. May it please the court, my name is Joshua Carden, representing the appellants in this matter. This case presents the opportunity to clarify and reaffirm the core principles of Boyce versus City of Scottsdale, that a request for rehearing made to a Board of Adjustment does indeed extend the time in which the requester can take an appeal to the Superior Court. The jurisprudential trick in this case is that Boyce was decided before the Arizona Supreme Court's decision in Legacy Foundation, which used a different language to talk about the time limit for filing an appeal to Superior Court. Whereas Boyce couched the time limits in I'll say the older term of statutes of limitations, Legacy adopted the phraseology of a limited grant of appellate jurisdiction premised upon timely action. And I don't think that renders Boyce invalid, even though it uses the different language, because the core principles remain the same. In Boyce, you have a Board of Adjustment, not unlike the one we have here. You have a timely request for rehearing that's made and later denied, and then you have the 30-day time clock that the Boyce court, this court, ultimately said that's when the 30 days restarted, essentially from the date of that new decision. Legacy, on the other hand, is a direct appeal from the Clean Election Commission, and intriguingly, even the authorizing statutes for the appeals have different language. So, for example, in ARS 16957, the appellate language that says you have 14 days to go to Superior Court, you have 14 days from the date of issuance of the order assessing the penalty. It's a highly specific, directed event that triggers your 14-day time clock. In the Board of Adjustment statute, in contrast, the statute says a person aggrieved by a decision of the board may take the appeal within 30 days. The Phoenix ordinance at issue 303 is even broader. It says any person aggrieved by any decision of the board, not just a decision, but any decision.
And with that language, do you even need Boyce?
I don't think you do. The nice thing about Boyce is it is what clarifies that Board of Adjustments are legally authorized when their operative statutes say you can adopt rules and that govern your proceedings, any rules that are for the convenience of the board. When it gives that broadened authority in the delegation of those powers, I think Boyce is still important for that reason. And the other thing to me that distinguished Legacy from Boyce is, and Justice Bullock wrote this very carefully, he said, if you're going to come at this by trying to attack the jurisdiction of the underlying agency, saying you didn't have personal jurisdiction or subject matter jurisdiction, you don't do that via a late direct appeal. He says several times, several points of emphasis, that this was a direct appeal attempting to use the very statute 16957 that prescribes a 14-day time limit. And to make it even more explicit, at the end says we express no opinion on whether some other method, i.e. a generic special action or a Rule 60 motion, some other vehicle might still work for Legacy to get the relief it's seeking. So when we've got that language in legacy, the only conflict between legacy and Boyce still seems to be Boyce's phraseology in using the phrase statute of limitations, that this 30-day time clock that's set forth in ARS 9462-06 is a statute of limitations rather than what legacy calls it, and what seems to be where the Arizona Supreme Court has gone with this is that's a limited grant of appellate jurisdiction instead. So, Boyce has been recited by this court as recently as January of this year in the Kleckner case. I think the core concepts are still good law, but I do think some clarity is going to be needed given Legacy's use of the phrase statutes of limitation, Legacy's use of the phrase limited grant of appellate jurisdiction, and Boyce's, call it outdated, use of the phrase statute of limitations. I'm sorry.
Well, I'm curious, as long as we're talking about time definitions, one of the doctrines that I think you're relying on is referred to as code, which is
Right.
a statute of limitations concept. I wonder analytically if you think tolling is even the right concept that is necessary to develop.
I don't actually, and the lack of precision between the words reconsideration and rehearing below, I think, is also causing some angst, especially when you read it with a judicial eye, because as we know, motions for reconsideration don't extend any times, and motions for rehearing or motions for new trial do. The statute says the board may rehear. It doesn't say reconsider, may rehear. It's not tolling when an appellate body, which is essentially what the Board of Adjustment is by statute, is asked to rehear a prior decision. All that does is it extends that appellate body's plenary power to reconsider or rehear the matter if it wants to.
So if one were to take a pure textual approach to the statute, it seems to me the question just boils down to when was the decision made?
Correct. When was
April or May?
when or it's a little more fundamental even than that, Judge Swan. I think it's when was an appealable decision made, because there were two decisions made. We're arguing in this case, just like there were in the Pond First case. There was the original decision that overturned the zoning administrator. There was in the Pond First case a timely request for rehearing, and according to Boyce, that would start the clock again once the Boyce keys off on it being the request that restarts the exercise of appellate jurisdiction. By the way, it's not whether the board decides or votes on it or refuses to vote on it or what have you. The timely request is what started the clock according to the Boyce decision. And then the board, in this case, it says no motion was made, the prior decision stands. And so I again would argue that that is not unlike the petition for review process or anything else where we're used to saying, are there enough votes, are there any votes, are there enough votes to take this up a level? And if the answer is no, the prior decision stands, petition denied, you use whatever phraseology you would like, but that's the new event, that's the new decision that starts the clock running again for purposes of an appeal.
Let's go back to tolling for a second.
Sure.
Do you think that tolling, the Boyce tolling concept, hurts your position in any way? I mean, if you rely on that, is that detrimental to your position?
No, but only because of phraseology, and this is what I was getting at before with the clarification of sort of shifting into this being a grant of appellate jurisdiction versus tolling is what we think of when we think of statutes of limitation. And the legacy decision pretty clearly says these really aren't statutes of limitation. They really are specific grants of jurisdiction on an appeals court, in this case the Superior Court, and legacy even says that. And therefore the question is, does the statute extend that grant of appellate jurisdiction by its operative terms. And our argument is conceptually from Boyce, that's exactly what's happening. The statute authorizes it. The board's allowed to adopt that concept because it's in the authorizing statute. This board has adopted that concept, and it's time limited. It's not a, we can reconsider any decision at any point. There's a very short time window. You have to get your request in if you want to ask the board to rehear it before the next meeting.
No, I was just wondering real quick, is it clear that you can't ask for another motion for reconsideration?
Well, that's kind of where I was going with subsection K, because during the pendency of any of these proceedings, something is allowed under subsection K.
Correct.
It's unclear to me from the language of the statute whether that's referring to the conduct that a party might engage in pursuant to a decision, or whether that refers to legal proceedings concerning the decision.
I think going to the board rules themselves would be the only way to analyze what this board has chosen to do with the process of rehearing. So in looking at that, you have, it's not an endless series of reconsiderations. It is an appeal. So to me, that phraseology says, and this is from the ordinance.
Well, okay, but let me give you a hypothetical.
Okay.
Just to direct it. If there are no votes to take up the request to reconsider, then a request is made in June to reconsider again, and there are no votes to take up. Would you say that an appeal would then be possible in July, or would you say that the June request was barred by the board's own rules?
The June request is barred by the board's own rules.
So do you think that subsection K has any bearing on the case at all?
Only to the extent that it is what authorizes the ordinance. So like the Phoenix can't confer jurisdiction on the Superior Court. Phoenix is allowed to make an ordinance that allows for a rehearing process because 46206 allows for that.
The legislature confers the jurisdiction.
Correct. So the legislature created that jurisdiction, and the operative language of subsection K is simply saying, after the board, a person aggrieved by a decision of the legislative body or board is allowed to file that complaint within 30 days. So I think you still need K because that's what allows you to get to court in the first place.
What about the other aspect of K, that the filing the complaint in this? So filing the complaint in the Superior Court does not stay proceedings on this decision sought to be reviewed. So in theory, you could still, your client could have filed the complaint in Superior Court and continued to seek reconsideration at the same time. Or am I misreading that?
No, you're not misreading it. My understanding of what that is referring to is whatever happened below is going to continue on. In other words, if the zoning administrator was reversed by the board and there's no stay granted, then the underlying property owner can proceed at their peril.
Well, that was my initial question about K, but taking Judge Brown's question, what if you filed a complaint in Superior Court after the April decision and still sought reconsideration simultaneously? Would that have been a viable approach?
I think there's a question as to whether the Board of Adjustment would have retained jurisdiction at that point, because the special action would have been taken. It doesn't state proceedings on the decision sought to be reviewed, but it does not talk about whether the board, and the board rules are silent on this as well, as to whether the board can even still act. There are other examples. I think I used the State Board of Adjustment. There are a couple of other examples where once you appeal from that administrative body, that's done. You stop there.
But subsection K is certainly not worded that way. I mean, we're used to thinking that way in terms of court. When you file a notice of appeal, the lower court loses jurisdiction.
Sure.
But subsection K almost seems to say the opposite.
Does not stay proceedings on the decision sought to be reviewed. I still am. I guess I've been reading this with too much of an eye towards the Board of Adjustment in the sense there that the underlying just the decision itself stands. It's not. It's maybe the word proceedings is what's throwing.
I think that part is fair, but that's not the hard part. The hard part is, does proceedings on mean conduct pursuant to, or does it mean legal proceedings?
That's a much tougher question. I would argue that it's you get to that the decision, whatever happens procedurally as a result of the board's decision, is allowed to stand unless the court comes in and stays it, so that the actions of the parties are unbound by the fact that a complaint has been filed in Superior Court. And that's my reading of K.
Well, it's to look at Boyce. One of the, if I remember correctly, Boyce talked about judicial economy. That's one of the underlying themes.
Yes.
Which approach, my suggestion that you could have done the two side by side. You could have filed in Superior Court, and you could have filed the request for reconsideration at the same time, or the way you did it, which promotes judicial economy.
The latter promotes judicial economy, and I think that's in the court. This court talked about that at length in the Austin Shea versus Phoenix case from 2006, where explicitly the court said this, quasi-judicial bodies should be given the first opportunity to correct their own mistakes. That is judicial economy at its bedrock. The other methodology, if it's required that you file with the Superior Court either before or simultaneously with requesting the Board of Adjustment to reconsider, all that means is a lawsuit is going to be filed every single time. That cannot be judicial economy.
I wonder also if the appeal is sound. You keep comparing this to the appellate process, but isn't this one of the original challenge? You're here on appeal now from the Superior Court ruling. That's a is the nature of the review that's sought in the Superior Court complaint an appellate style review with a standard of review, or is it simply more in the nature of a special action?
My understanding is that it is a decision for review. It's in the nature of a statutory special action, not the true independent, former writ of mandamus and all of those. But I'm trying to use the language from Legacy, because that seems to be the language that the Supreme Court is going with. That they call it a special action. Justice Bullock refers to it repeatedly as a direct appeal, and he specifically says these provisions, and he's referring to taking a claim up either to the Superior Court or to the appellate court. They're not statutes of limitations, but confer limited appellate jurisdiction subject to timely action by the appealing party. And he refers to it as the appellate court, and even explicitly says here the Superior Court of jurisdiction. So at least that decision really seems to ground this in more of the appellate construct than a typical filing for a review, although that's what it's called in the statute. We're asking, we're asking the Superior Court to hear a special action to review the legislative body or board decision. I see I have 2 minutes left. I'd love to save a thought or two for rebuttal, if I may.
That's fine.
Thank you.
Thank you. May it please the Court. I'm John Willenschek for the appellees. What Legacy fundamentally changed was to say that whenever you have a right to appeal that's created by statute, it is jurisdictional in nature. And in doing so, it cites the cases, even older cases, that talk about this court.
That's hardly a novel proposition.
Under Boyce, it was novel because...
We dismiss appeals here every day because they're
Correct. That's absolutely correct.
lack of jurisdiction. That's deadly.
Absolutely. The problem with Boyce was that it talks about rights to appeal from administrative agency actions, like a board adjustment proceeding, as being statutes of limitation. That's why Boyce is wrong. That's why it committed error. And that's why it's no longer viable under the legacy decision. Legacy is clear that, just as you say, and it's not a novel proposition, whenever you have an appeal, a right to appeal, it's conferred by statute, it is jurisdictional nature. And there's many cases all across the country saying, like you say, that's not a novel proposition. When something's jurisdictional nature, it cannot be waived, cannot be told. I think an important question raised by the argument that's been given here is, well, what exactly were they appealing from? They want to convince you now they were appealing from this decision by nobody on the board to make a motion to reconsider. The substance of their appeal below was clearly, their appeal to the Superior Court was all about the decision by the Adjustment Board not to reverse the decision by the zoning administrator. And if you look at the actual statute, which we have, 9-46206, that confers, that creates the powers of a Board of Adjustment, it talks only about its power to, quote, hear and decide appeals in which it is alleged there's an error made in an order of the zoning administrator, and its power to reverse or affirm in whole or in part, or modify the order of a zoning administrator. That's the decision they were appealing from. They want to convince you now that, well, under the rules of this board, it said that you could request a reconsideration, and then if one of the board members wanted to and was present from the prior meeting and voted in favor of it, they could reconsider. That's not what they're appealing from. They're not appealing from the fact that nobody decided to reconsider. In fact, they've argued it was impossible for anybody at that second meeting, the May 3rd meeting, to reconsider.
Wait, where's that argument?
They make that argument in their opening brief. They sort of mention it in passing, I want to say towards the beginning of the brief, that, and it was sort of argued below as well.
Are you suggesting that they're admitting that the entire request for reconsideration was just a futile gesture that never had a chance without regard to the court process?
They have made that argument, and the reason they're saying that...
Why would they do
Explain that. Is that because of the makeup of the new members, or can you explain that a little
That's
bit?
right. As best I understand their argument, it's their argument, but they're saying that all the board members, a substantial majority of the board members from the prior meeting were replaced right before this meeting at which the request for reconsideration was on the agenda.
Isn't that the optimum time to request reconsideration?
It would, but as I say, they're arguing that it wasn't impossible for that board with that composition at that point, given its own internal rules of the board, to grant that request. So the only point I'm making there is, again, that's clearly not what they're appealing from.
So what, if you were to speculate, why would they make a request that they know to be absolutely futile?
If you look at the request itself, which is part of the record, it's like a 1.5-page letter that was written. First of all, it is clearly in the nature of a motion to reconsider. There's no new evidence in there. There's no new anything.
That's not my question.
Sure.
I've seen the letter. My question is, why, if your argument hinges at all on the notion that this request for reconsideration was inherently futile, a complete fool's errand, and that you are in lockstep on that position, why do you think that the appellants would have ever made the request? Why not just file the appeal if the reconsideration is completely futile?
It's a great question, and I don't know that argument does hinge on it at all.
Well, I suspect we'll hear in about 15 minutes and 44 seconds exactly why that was, or if they even agree with your characterization. But if this point is logically necessary to your argument, I want to understand what you think was going on the other side.
To be clear, I don't think it's logically necessary, but the answer is the same reason everybody files a motion to reconsider. They want to delay the process. And that's one of the reasons, by the way, you raised judicial economy, Judge Brin. The reason why judicial economy cuts in our favor, and this is what was said by the Arizona Supreme Court in that Scottsdale paint and varnish case, is that if you allow motions to reconsider to toll time, you encourage people to file them, and they should be discouraged. We all know that motions to reconsider are pretty much always denied, particularly when they raise no new issues, no new anything, and are just basically saying, hey, you made a mistake.
You'd actually take a lot of my workload away if that were true.
And that's exactly what the Supreme Court says in that Scottsdale paint and varnish. It says they should be discouraged. So if we're going to talk about policy reasons or judicial economy, that's the best premise of all, is that if you allow, as they're arguing, for a motion to reconsider to toll the time which to appeal, you're encouraging them to be filed in every case.
And if we were a legislative body, that would be an interesting argument, but we're not.
Correct.
What you have to do is apply the text of the statute as written, and,
Exactly.
and the text refers to a challenge to a decision. The question to me, as I walked in here, seemed to be, when was the decision made?
You know, I think you're exactly right. And the reason is, again, analogizing to our Court of Appeals here, you have a statute that defines certain orders as being appealable orders. So I look at ARS Section 9-46206, particularly subsection K, but also the rest of the statute, and I look at this as the analog of that. This is what defines appealable orders from the Board of Adjustment. And what kind of orders does it talk about? Again, it only confers, in fact, power on the board to make one kind of order here, or to reverse or affirm in whole or in part, or modify the order of the zoning administrator. That's the appealable order. Just like in this court, motions to reconsider are not appealable orders. It's a final judgment. It's one of the appealable orders listed under the statute. So the point about not staying proceedings is very critical because it indicates that legislative intent. Not only the fact, like I just said, that the only order it even talks about is that actual order to reverse, affirm, or modify the zoning administrator's order.
Since this entire one seems to be conducted in terms of analogies, what if we analogized it to special action proceedings in this court? If you file a special action challenging something the Superior Court or however some state official does, absent a stay by this court, nobody loses jurisdiction. They're free to consider, reconsider, enforce, all that while the special action is pending. Isn't that all that subsection K says?
Well, to be clear, it does say subsection K contains the 30 days. It has that 30 days deadline from the decision of the board.
No doubt, but it doesn't do a very good job of defining a triggering event.
So your question is that all that this language about staying proceedings does at the very end of that? I read it as another indication that when it talks about a decision, it's talking about the only kind of decision that it confers authority on the board to make, which is, again, this decision to reverse or affirm in whole or part, or modify the order of the zoning administrator. And when it talks about staying legal proceedings, I think the court is correct that it's referring to, it is referring to legal proceedings. Otherwise, it would have used the term like enforcement of the decision, something like that.
And there's a strong textual argument to say that means just legal proceedings aren't stayed. Fair enough. But doesn't that sort of move subsection K then into a land of irrelevance for our purposes today? If that's the right reading, I don't see how it bears on the dispute. And quite frankly, if your colleague's reading is the right reading, I don't see how it bears on the dispute today. I'm not sure that subsection K is as important as subsection K.
To be clear, you're talking about the last section of K. So you're not clear. I understand what you're saying.
I'm sorry.
You're saying the last sentence of K does not have necessary bearing. And I tend to agree. I think the only bearing it has is that it is an indication that what we're saying is the case, that you can continue with legal proceedings, i.e. a motion to reconsider, even after an appeal is sought. Just in the same manner that's the way it works with this court.
Of course, the problem with that is what kind of proceedings would still be ongoing? After the board makes its decision, what proceedings would be stayed? It seems that there would be none presented.
The answer is exactly what we're talking about. It's requests to reconsider. And that's why the only significance...
But wouldn't it be weird to say, it would make no sense at all to say a request to reconsider is stayed. Right? If you're going to say the filing of a request for reconsideration stays the request for reconsideration, that would be absurd.
I tend to agree. I think it's really just a motion to reconsider if there's actual proceedings on it. And that's a very well taken point to me because there was no actual reconsideration here. They filed a request which just puts it on the agenda. No board member actually made a motion, but my view what this staying proceedings refers to is if a board member actually had made a motion, they scheduled a rehearing. That can proceed just as technically, theoretically, can proceed with this court below. Courts can hear motions to reconsider even while an appeal is pending.
Well, not superior courts.
The superior courts can hear motions to reconsider while an appeal is pending.
On the
Whether
merits-
that's a good idea or not,
The merits of the case?
they can, absolutely. We won't get off track. That is true, they can. I've had that happen.
Come teach us CLA. I'm not
Yeah.
sure that's right.
Courts can act in furtherance of the appeal, which
In furtherance of an appeal,
which
not-
includes fixing their own errors. There is authority to say they can look at a motion to reconsider, and should it be granted, the appeal should be dismissed. But they
You may
can
be
do.
describing a different appellate system than the one you're in today, but we're
Not-
talking
we're not here about that
analogies,
anyway.
so let's stick to the
Sure.
argument before
Sure.
us.
The bottom line is that the subsection K not talking even about this last sentence, but subsection K says you've got 30 days to appeal. There is no legal authority that said they had any more than that, period. And what we have in legacy is that these kind of deadlines are jurisdictional. So you have to be pointing to something somewhere, a rule of any relevant, tribunal that says you have more time. You can't apply tolling. Legacy said, look, you can't even make this creative argument like they did in Legacy, that our appeal is saying the court never had jurisdiction and therefore, we're not bound by the 30-day appeal deadline. It's Legacy saying there are no exemptions. This is jurisdictional, just like you say. It's not a novel idea. The right to appeal to this court is.
If we can use the statute of limitations vernacular for a moment, the only question here is who. Right? I mean, we know what 30 days means. 30 days from what is the question?
Okay.
And is the failure to take the issue up effectively a decision not to take the issue? That's really what this case boils down to, isn't it?
I think it's a fair characterization. In my view, that's basically the analysis of what is the appealable order, both in practical effect, i.e. what are they actually appealing from, and legally, what are you allowed to appeal from under the statute, 9-462 of 06. And what I'm saying is, one, as a practical matter, they were clearly appealing from the actual order to reverse the zoning administrator. In substance, in practical substance, that's what their entire appeal is. They're not appealing from their request for somebody on the board to reconsider it. And then two, I don't think that even would be an appealable order under the statute as written, given it only talks about the board's power to appeal from, or the aggrieved party's power to appeal from. Let me be clear. It only talks about the board's power to enter orders reversing or affirming the zoning administrator. It doesn't talk about motion to reconsider or the failure to take one up. So under the statute, that's the appealable order. It talks about when it confers this power, this ability of an aggrieved party to appeal. And as a practical matter, that is clearly what they were appealing, the actual decision to reverse the zoning administrator. There was a question raised about, whether we should be talking about this nature of right to appeal. I think the parties all seem to agree here, if I understood opposing counsel, that yes, this is a right to appeal. This case law is saying that, these boards are basically quasi-judicial. I don't see any authority to say that they're not judicial in nature and that we're not talking about, like you say, a rather, non-novel proposition, that we're talking about appeals here. We're talking about jurisdiction to hear an appeal. Unless the court has questions for me, further questions. That's all I have to say. Thank you.
Thank you.
The reason is that the request for reconsideration was made on April 30th of 2018, and the entire board was replaced on May 2nd of 2018, the day before the meeting that they had where no motion was made to reconsider the decision. At the time that my clients made their motion for, put the request in for rehearing, there was, I can't call it a motion, it's a request. Only the board can make the motion. They had no idea that the entire board was about to be replaced.
That doesn't look like a request for you.
No, it certainly does not. And something finally crystallized.
Hope to someone seeking reconsideration.
Right, it would seem so. The board rules say that only, however, a motion can only be made by someone who voted with the majority in the previous decision.
Essentially, Robert's Rules of Order.
Basically, yes. Something finally crystallized for me on the proceedings language in K, and it is that the statute doesn't contemplate rehearing. It just says the board can adopt rules. The ordinance talks about rehearing. So what proceedings are we talking about? And I think it is that there is no stay of the board's decision pending the complaint unless the court grants one. So proceedings does not textually include by itself, it's not contemplating rehearing per se, because there's no obligation for a board to have a rehearing procedure. So that has to mean proceedings on the decision, meaning the decision being carried out by the department the zoning, the applicant can go forth and build their pink castle or whatever it is. So that is why I think that the proceedings in the stay is not limited to the rehearing concept. I see that my time has expired. If there are no other questions, I'll sit down. Thank you.
Counsel. We thank you both, counsel, for your fine arguments this morning. We'll take this matter under advisement and issue a decision in due course. We'll take a brief recess to prepare for the next argument.